Okay, welcome back, everyone. We are going to take up the bill concerning the Human Services Board. And this morning, we have with us the Chief Hearing Officer of the Human Services Board, Joe Reinert, and welcome.
Thank you very much.
And because this is your first time here, we like to do introductions all the way around, so you know who you're speaking with, and just so people around the outside know, you'll be asked to introduce yourself as well. My name is Teresa Wood, and I'm from Waterbury, and I also serve Bolton, Buell Score, and Huntington.
Van Donahue, Northfield, and Berlin.
Hi, good morning. I'm Dan Noyes. I represent Wolcott, Hyde Park, Johnson, and Belvedere.
Brenda Steady, East Milton, Westford.
Hi, Doug Bishop representing Colchester's Chittenden 20 District.
So I'm Joe Reiner with the Human Services Board.
Todd Nielsen, I represent Brandon and Forestdale.
I am Jubilee McGill and I represent Bridport, Middlebury, New Haven, and Weybridge.
And I'm Ray Garofano. I represent Essex and Essex Junction.
Reverse Committee Assistant.
Brenda Spiegel, Executive Director at Homelessness Vermont.
I'm Sarah Kelleher, I'm an intern for the Public Health Conference.
I'm Andrea Smith. I am with Vermont Lead.
I'm talking McFawn, I represent Barry Town of Powder Wooding South.
Thank you, and it's Representative McFawn's bill that we're taking up. So Representative McFawn, feel free to ask questions as we go along, okay? After you're recognized, of course.
I'm well aware of that.
I know. Sometimes we're free flowing in the room sometimes. So welcome to our committee. And just to give you some background, obviously you know that the Human Services Board plays a really integral part in the fair decision making and access for individuals that the Agency of Human Services provides supports and services for, either directly or through their community partners. And I've been here 10 years now, and we haven't done any kind of review of the Human Services Board. And my predecessor said she couldn't remember having done it. And we actually have had some I'm not going to say concerns per se, but questions raised about, particularly around how individuals themselves, how the person whose appeal is being heard, how they are, or maybe in some cases feel like they're not really able to access the board or the hearing process, or find difficulty in doing so. So that's sort of like, give you a little bit of background about one of the reasons why we want to learn more about how the Human Services Board actually runs. We did have an overview by Katie McClin from Legislative Council. Human Services Board is mentioned in a lot of statutes because the Agency of Human Services is in a lot of statutes and all the various programs. So we really appreciate you being here today. And committee members, we have a number of documents that Joe has provided on our committee page. And thank you again for forwarding the annual report. I'd taken a look at that previously, so that's helpful to have. And we appreciate you being here, and the floor is yours now.
Well, thank you very much for the opportunity to provide testimony. Again, I'm Joe Reiner. I'm the Chief Hearing Officer of the Human Services Board. I worked for the board for about 12 years as a hearing officer and became the Chief Hearing Officer about 6 years ago.
Can I ask a question?
Sure.
How do you like to have questions?
I find to be anytime someone, in terms of I don't have prepared remarks. So
Okay.
If anyone has a question,
Okay.
go ahead and ask.
So, all right. So my first question is, when I saw the title Chief Hearing Officer, it implies that there are other hearing officers. So are there other hearing officers? How many of them of you are there? And I had a chance to look at the budget. People might be interested to know that's nearly $1 million. You hear a lot of cases. So could you describe maybe a little bit, and maybe you were going to do this, so my apologies for interrupting, but really sort of like, what's the makeup of this process in state government, you know, in terms of how many staff there are, how many, you know, how does the board itself work? You know, does the board actually only hear what the hearing officers tell them, or, you know, is it in summary, or, so if you could just kind of, do what you've started to do, and my apologies for interrupting. I just realized that, I should just let you start, so.
Well, that's okay. I mean, I can start with that. There is some information about that contained in the memo, and I understand. I just sent that this morning, so.
Yeah.
So there are, including myself, there are 3 hearing officers for the board statewide. There's some history about that. I think up to about 10 years ago, 10 or 11 years ago, there were 2, and then that expanded to 4 with the health exchange, with funding for that. And then that was then reduced to 3 after a couple of years. So we all have a caseload. I have additional administrative responsibilities. So that's, and then we have 2 administrative staff, a total of 5 staff. And we have had, you know, we've had some vacancies. So I would guess that we haven't been fully staffed for a great part of the last, I don't know, 3-4 years. But we are currently now fully staffed, and we have been for about a year and a half. Well, I shouldn't say that, because we had to hire we had an admin vacancy that went on for quite a bit. So as of September of 2024, we're fully staffed. So I guess I do want to address kind of the second part of your question, and sort of a little later on, in terms of how the hearing officers interact with the board. And again, there is some information in the memo I sent about that. But I do want to start out sort of with a bigger picture of, and I lay this out here. So the board's an independent board. They're citizen board, 7 members appointed by the governor. The hearing officers are appointed by the board. They are approved by the governor. And the board has jurisdiction over a lot of issues. I would say some we don't see a lot, you know, so, but if they're included in that list of issues. And I'm not going to go through all of them, obviously, but I would say that they divide up into 2 basic categories. One is sort of benefits, and it sort of tracks how the agency operates. And the second are kind of more regulatory and protection functions of the agency, licensing, childcare licensing, foster licensing, and then you have child abuse substantiations, vulnerable adult abuse substantiations, long-term care discharges, involuntary discharges. So those are the 2 main areas. I haven't looked too much into the history of the board. I know it goes back to the 70s, and it started with, I think, a necessary aspect of the public benefit system, because of cases that developed that required a certain amount of due process, likely like Goldberg v. Kelly, which is, you know, probably 50 years old. And then as things changed, the board acquired jurisdiction over other issues, and that's sort of more the licensing, child protection, and vulnerable adult protection. So, but the foundation is in the due process requirements around public benefits. So I've laid out kind of the different programs, and many of them you're probably familiar with, just because, you know, it's Medicaid. And Medicaid, by the way, is as you may know, it's just a huge part of the benefit system, because there are so many different programs. You have the global commitment. So it just brings in a lot of different things.
When you say benefits, do you mean, do you include in that category eligibility for those benefits, as well as changes or termination of benefits in that overall category?
Yes, yeah, absolutely, yeah. And so there are different rules that apply to you know, whether it's an eligibility decision or, as you mentioned, a benefit change or reduction or termination. As you know, as long as this list it is non-exhaustive because the enabling statute and the jurisdictional statute of the board is kind of open-ended. And I've quoted it here, I've attached it here, but I'll just read it. It's all appeals from an applicant for or a recipient of assistance, benefits, or social services from DCF, DEVA, Dale, DMH. So there are still situations where we might receive an appeal where we actually haven't seen the program or issue. It just wasn't on our radar before. The departments do a good job of letting us know if there are new programs that fall under the board's jurisdiction, but nonetheless, I mean, until you actually have the case in front of you, to be honest, you don't really think about it as much. So I do want to pull out of this list the general assistance housing because those fall a different track. They're scheduled much more quickly. They have to be decided much more quickly, maybe for obvious reasons. And so we don't actually have rules that specifically apply to those cases. And so we essentially hear those cases essentially by agreement. I mean, they fall under our jurisdiction, but the expeditious nature of them, how we handle them, how we process them, is different from how we handle other cases and different from what our rules say a little bit. So,
a question on that. Has that, I guess the housing program has existed for some time. It's obviously, as we all know, grown significantly since COVID. Has there been talk about better defining the set of rules that are utilized in that process? Now that we're a few years into sort of what I imagine is the uptick in requests.
There hasn't been yet. I mean, I think, I can't speak, say, for the advocate community about how they view the process per se. We've had a couple meetings with legal aid, and Brenda's been involved in some of them, and as well as the department. But no, that we haven't. That hasn't come up. The basic process of the board is, I guess, in a way simple, which is we receive an appeal, we schedule it, we hear it, we decide it. The hearing officer doesn't make any final decisions in most cases. We'll make a recommendation to the board. The board then has to decide whether to adopt that recommendation. And then that's pretty much it. There is an appeal to the Vermont Supreme Court. Some of the cases are reviewed by the agency secretary or reviewable by the agency secretary. We have experienced a very high number of cases over the last couple of years, in part due to the GAs, and in part due to the fact that the Medicaid, the unwinding of Medicaid eligibility that occurred post-pandemic. So I think I state this in my report, but obviously we're hopeful that, that's going, that we're not going to continue seeing that number of appeals simply because it's probably not sustainable for us in the long run. Or we get more resources.
Can I ask?
Yeah.
Oh, sorry.
Go ahead, Representative Cole, and then Representative Bishop.
About the frequency of maybe disagreement between your recommendations and that of the board itself, and maybe the nature of those kinds of, if that is a thing, the nature of those kind of disagreements and how those decisions are made, based on the board, what information they have to come to a conclusion versus what information you do.
Yeah, I don't have actual numbers on that. I'm not sure that I don't know that I could get those. I might be able to. I think that there's probably a fairly high approval rate of the hearing officer's recommendation, I would say, pretty high. So the way that, and maybe I'll get into sort of the way that process works, because Chair asked about that. And so, what's issued to the board is the hearing officer recommendation. It contains proposed findings of fact and a recommendation on the outcome. The proposed findings are there's deference to the hearing officer in terms of making findings. The recommendation of the outcome is, there's no deference in that respect. So the board could, in order to basically disregard the hearing officer's findings, the board has to find good cause. For the recommendation part, there's no need for that. So, however, we don't send the entire file to the board. If they want information from the file, they can see it. They receive our proposed findings and our recommendation of what we think should occur. And then the parties are able to come to the board meeting and argue one way or the other. If they think the hearing officer missed something, didn't include something, made a mistake of law, then that's how that process works. So there is a little bit of a separation between the fair hearing process and the board process.
So I just want to make sure that I understood that correctly. So the person who is appealing, so they appear before the hearing officer first, and by whichever method, is chosen. And then at some point, the hearing officer provides their written findings and recommendation to the Human Services Board. And then, is that in all cases? Because some of the information we got yesterday indicated that actually the decision of the hearing officer is final in some cases. Or do all of your recommendations, do all of your findings and recommendations go to the Human Services Board?
Well, yes. I mean, if they're necessary. I don't know in what cases the hearing officer makes a final decision. There is only one area where that's permitted by statute, and that's in expedited Medicaid appeals, which we don't really receive. And I mean, we've received a few. So what can happen is the hearing officer can issue a recommendation, and the department can voluntarily implement that. And then there's a question. One, often those cases are withdrawn. Often they're withdrawn even before there's a recommendation. Sometimes they're not withdrawn, and so that raises the question whether they're moot. If the department has agreed to implement the relief requested by the petitioner. But we do not issue final decisions except in that very limited situation. I mentioned in here intentional program violation cases, which are basically, food stamp fraud. Sorry to put it that way, that's just what they are, but they go back many years. So those cases are not within the board's jurisdiction. They don't need to be sent to the board, and they just get issued by the hearing officer as final decisions. As a practical matter, of course, I mean, the hearing officer can give a weather report, can issue a preliminary memo, can push the parties on the legal issues and the factual issues. And if there's ultimately a resolution, I suppose you could interpret that as being that the hearing officer determined the outcome, but that is not informed the way our system works. And that is, in fact, the way a good adjudicative process that includes parties on both sides should work. Which is that that people should have the opportunity to resolve cases on their own short of a fine order. And
Sure. And then is the Human Services Board informed of that at all? Or is that just like something that is kind of behind the scenes? And if everybody is agreed to, to a resolution, before it actually gets to the board situation. So I'm just trying to figure out how much information the Human Services Board actually sees or gets.
No, I mean, it depends. Probably in most cases, the board is not going to know about an individual resolution. There are some cases that end up on the board agenda, which go off the board agenda because they get resolved. Okay. In those cases, they may know that.
Yeah.
Just to step back. So once the case is scheduled and set for hearing, it's possible that it gets resolved even before there is a hearing. And that's quite common. that the department will reach out to the petitioner and resolve it in some fashion. And so we'll get a withdrawal. We confirm all withdrawals in writing. And then there are cases that work out after the fair hearing is sort of process starts, where there's been a hearing already, and there's been some discussion of the issues. And so, we're not privy to those outcomes. And it's within the discretion of the petitioner to withdraw the appeal. And often we don't know why. Sometimes we do. I would say that if you were to look at our statistics, and I could also drill down a bit on them, which is that it's a fairly effective process for resolution of grievances by people. In other words, there are a high number of cases that are withdrawn where we know that it's withdrawn in the petitioner's favor. There's a high number where we don't know, where I think it's fair to assume that a significant percentage of those are withdrawn because the petitioner received a positive outcome. So I'm speculating a bit here, but I do think it's an effective process in that respect. For a case to get to the board, it means that there's been no possibility of resolution.
Thank you.
Question.
Go ahead.
A few minutes back, if I understood correctly, you said we're talking about the volume of cases and how it's at or verging on sort of unsustainable. And if I understood correctly, you said, absent being able to have more staff, we'd have to find a way for fewer cases to be heard. How can is that something that's within the Human Services Board or hearing officers' control, because others are filing? So how can you tell me more what you meant by that?
Yeah, I guess I'm just being, careful, conservative about saying we need more staffing, because I've been with the board for 12 years. We have a sort of longer track record of sort of the norm of appeals we receive. We've had 2 years of very high numbers, and we can track that to Medicaid, which is unwound. So the number of Medicaid recipients has gone down because they were, kept on Medicaid during the pandemic, and then general assistance, which has already is getting a little smaller, I think, since the height of the pandemic, but maybe I'm wrong about that. So that's why I say that, is that I would want to be careful about knowing that we have a long-term increase. Sure. So one thing I do want to say is that there is a very wide range of complexity to cases. So, so in other words, we're going to get very typical sort of income threshold cases where there's really only a couple of issues. One is, how is income counted into what's the income threshold? But we also see a lot of cases that are a lot more complicated. And ultimately, our decisions have to pass muster. They can be appealed to the Vermont Supreme Court. We have to ensure that what we do is legally sound. So I think it's so despite the fact that cases can be complicated, and despite the fact that we have a lot of unrepresented petitioners, we still need to ensure that we are covering all of the legal issues and developing the record so that we're able to make a decision that can pass muster. I've gone in here about kind of our other sort of, more mechanical processes. I mean, we start out by phone. We sometimes do things by video. We sometimes do things in person. We've got a very active motion practice that we have to deal with, because even when petitioners aren't represented, we just see a lot of motions, requests, evidentiary issues. the hearing officer does have a lot of discretion within the process to decide, okay, we need an evidentiary, or this is a legal issue, or, I'd like to get briefing on an issue. So there is a fair amount of discretion within that process, who gets to testify. So, that just varies. That just varies by case. We have cases that are a couple of days of hearing. Some are there 30 minutes.
So, are there guidelines that you send out to people who are appealing, like, so they know what to expect when they get to the hearing? So they understand, like, they can bring a witness, or they can bring a support person, or they, I think that sometimes feedback that we've heard is, it gets to be a quasi judicial kind of feeling setting. And if people know that in advance, that might help them to better prepare for that. But I know that in some cases, people have been very taken aback when, the department's attorney might object to something that they're saying, and they feel like they're, not really able to get out their side of the story, if you will. So what kind of notice are people given about what to expect?
I did provide, this is, I think, the first attachment.
We haven't had a chance to review this
Yeah.
analysis. We just.
So it's a summary of the hearing process. It goes through, how the hearing is conducted, how to prepare, how to access legal advice. I think, and we actually spend, I think, a fair amount of time when the hearing starts to talking about our processes, asking if people have questions.
It's right here.
We, I guess in my view, and we do try very hard to accommodate the needs of pro se litigants. And I think we do a good job of that. We recently had an audit of our 3 Squares program, and I think it's a 3-year window or 5-year. So there were no complaints about the fair hearing process within the audit. We have a complaint process. We let people know about it. If someone, in my time at the board, I'm aware of maybe 2 to 3 complaints in 12 years. We're talking probably close to 15,000 cases. I don't know. I haven't heard directly what you're referring to.
It's been mostly around folks with developmental disabilities and their services that I have sort of heard the most surprise at the process, I guess I would say, or understanding, or maybe lack of understanding about how that process would work. So we have a question here. Go ahead, Representative.
I was reading the preparing for the hearing. Very, very thorough. Thank you. Very thorough. And it says right here, if you have a disability and need assistance in connection with your hearing, call the board, and it gives a phone number to let us know. Special accommodations will be made at no cost to you. So is this sent to is it litigant?
Yeah, it's all sent.
It's very thorough. If you have a disability, if you need legal aid. So maybe they can't read, and that's probably might be the disconnect.
It could be.
It could be.
Yeah. There's a communication support project, which you may be familiar with. And so we do have some cases involving communication support specialists. So as far as dealing with kind of the legalistic nature of the hearings, and they are legal proceedings. Now we follow our rules require us to follow the rules of evidence. If if a party makes an objection to an evidentiary issue, we have to decide that. That's, I guess, there are resources for people to get legal advice and legal counsel. I recognize that the process can be very intimidating and difficult, and the issues can be complex. I think that, you know, we do our best to help people through that process. There may be other factors that will never allow us, and we can't be the person's attorney. You know, we can't give them legal advice. We can't really cross that line. So there's a little bit of a tension there, and we have to be the judge. And so I can't account. What I can say is that I recognize that there is going to be a certain number of people who are going to necessarily feel like, you know, they didn't understand and they didn't, and I don't know anything short of providing them with lawyers or being able to have advocates at the hearing. I think that, but that is not, I mean, that isn't necessarily, that doesn't mean we're not trying to help people.
I understand. Yeah. Go ahead, Rebecca.
Thank you.
You're fine.
Thank you for the information and thank you for the work that you do. I know, like, you guys have had a huge increase and not a lot of resources. So I really want to appreciate the work that you're doing. I'm wondering, you know, kind of putting myself in the place of the person that is coming in for the hearing. Looking at this, like, would you consider saying, right, like in the notice that you sent to people, that this is very similar to being in court? Because I think like that is missing for me, like at the top, like, yes, you're saying it's hearing, but I don't know if people really understand that, you know, if you're going through trauma or if you're, you know, in having disabilities, like really explaining that this is like you're in court and you have to kind of defend your position. And then I was also wondering, I'm assuming that the department's attorney is always present.
Yes.
Okay. And then do you have data on the percentage of the people, the complainants that have representation or have legal aid, have sought some kind of, like, what is the
Of the percentage of represented petitioners?
Right.
I could probably get that. I don't have it at my fingertips. So, you know, and so the best, yeah, so I don't have that. As far as the first question, you know, it's a fine line. I mean, we want people to, it could be a little intimidating to say this is going to be like court. It isn't like court. I mean, I think, like I said, I mean, I think we are far more accommodating court would be. I really do. So we sometimes develop the record so that we can get to legal issues that we think are apparent that the person hasn't raised, but we feel obligated to raise that. I think we do a good job of that, and that's important because they don't have an attorney. So if we think there's a legal issue that needs to be addressed, they don't necessarily have to raise it. And, you know, at least, you know, in my experience, often we have a discussion about the issues. We're not starting the case with, you know, an opening statement and testimony. We're just having a discussion of what we're going to do, what the issues are. We always give people the opportunity, if they want time, to consult with an attorney. We ensure that if they, you know, sometimes sometimes it's hard to get access to records quickly. So, you know, there's definitely situations where people want to make sure they have access to the records the department has. So we certainly try to accommodate that as best as possible. So, you know, I don't think we approach this like a court would. I think what I'm saying is that at the end of the day, when we issue a decision, it's got to be legally sound. So we will need to address legal issues. And some of them are very complex and,
Yeah.
and you just can't, you know.
I think that we recognize that some of them are really complex, and I think and not all the time do people understand the complexity of the rules that you're dealing with. And to be fair, I think that some of the contention really arises with the legal representation from the departments in the context of the hearing, and not necessarily with the Human Services Board hearing process. It's maybe, more in how the department's defending their position. So I have to unfortunately go to another committee just for a few minutes, but Representative McFawn has a question.
Yeah, I'm gonna have to go. No.
It's disintegrating here as we go.
It's that time of year.
Yeah,
I
yeah.
understand.
It's nice to see you in person.
Yeah.
We spent a lot of time together.
True.
I heard a lot about legal. I have had the opportunity to follow one family for it's probably 4 years now. And my questions are this: the number of hearings that this family had to go through was unbearable as far as I'm concerned. Hearing after hearing after hearing, on either the local level or on the road to the Human Services Board. There were times when evidence that the family was trying to present, they couldn't do it because they kept getting interrupted by the lawyer from the agency with the word, I object, and then on the other side, I find your objection valid. What does that do to a family who's trying to represent their son who cannot communicate hardly at all, can't speak? You can't understand when he talks. So that was devastating. They had a person with them that knew of the case, knew some of the laws, maybe not all of them, but was trying to help the family represent their son's case. And that person was shut down. So when this continues to happen and they continue to go to hearings, they finally get to the the other thing is evidence that they were trying to get into the record. They couldn't get it in. And as a layperson, I'm not a lawyer, but as a layperson, and I'm going before the Human Services Board, I'm going there to tell my story. That was not allowed. And that bothered the family terribly. When we would leave those hearings, the mother of that fella was crying her eyes out, saying, why won't they listen to me? Why won't they listen to the person that we brought in? My answer to them was, they're listening, but I don't think anything's going to happen about it. When we finally got to the hearing, the Human Services Board, that to me was a disgrace. I know some of the people personally on that Human Services Board. And when I was asked, do you want to speak by the chair? Why no? I spoke. I don't think they took one piece of evidence of what I said into effect in that case. So, to me, the reason for this bill is because I think people should be treated differently than being in a courtroom. That's how they felt. You may not think you're doing that, But that's exactly how they felt. They felt as if they were important. And for the lawyer to keep interrupting them when they were trying to get their case out, that got them so nervous. And feeling as if they should have had a lawyer. Maybe, people can't afford, lawyers are expensive. So, I think you need to change the way you're doing things so that people can come in there and they don't have to be subjected to that. They come in, they tell their story. You can ask questions if you need to, to get some of the facts straight. And then if you want to make a recommendation to the board, fine. But you gotta treat people where they are and not where somebody thinks they should be. That was a terrible experience for me. And I wasn't even the one that was trying to get my son taken care of. These people that I was with were willing to give their house to the state afterwards, after their son died. And none of that was facts, I don't think, ever got in to the Human Services Board. So.
You mean at the board level? You mean at the
When
board?
we went to the board, yep. I don't think those facts were presented to the board because I think they would have reacted differently. But anyway, I'm talking about the process.
Right.
Something's got to be done about that. You can't have people coming in and all of a sudden being thrown off guard by some lawyer. I object. And then a hearing officer says, I find your objection valid.
Representative McFawn.
They don't know what to do.
Thank you. Is there a question up there?
No, I'm telling them. The question is, can you change?
We're all capable of change, I think.
Oh, we try to do everything we can to help people. And I know it. I read the thing that was sent out. But that's not what happens when they get in there. And that's from my point of view.
Thank you for sharing your experience. I think that's really important to hear of the experience you've had with the specific.
And there are others too.
And yeah. And I'll just say, like, just from reading, and again, it's kind of reiterating what I said, but like walking into a room, a hearing that's not supposed to be like a court hearing, and seeing every time that there's an attorney representing the agency, but maybe not knowing that going into it, again, like maybe a little bit more clear communication that the other side will have representation and they will be able to kind of question you about, I'm just thinking about the power imbalance there and how that could be perceived that somebody, you're telling people that this is not a court proceeding, that's not what they should expect. But then when they walk in, it appears like it is, and it acts like it is because there's objection, and someone who may not have either been able to afford an attorney, but maybe thinking they don't need one because it's not a court hearing. Again, if the department is 100% represented by an attorney, then to me, that creates some sort of a power imbalance.
Yeah, so I think it certainly could, it could be incorporated into what we tell people, but I think there is a big qualifier. It's not a court. It's not a court hearing, and I've been in court a lot before I did this job. These are not court hearings, and I recognize that so I can't speak to an individual case because of confidentiality reasons. Certainly you get into an evidentiary hearing where there are disputed facts. It's true. You're going to see objections, and that isn't because of anything that we're doing. Our rules follow the rules of evidence, and that is a very formal requirement. I do want to say one more. I know there might be other questions, but I do see a lot of what Representative McFawn is talking about in terms of that there, it is difficult. We need a bunch of status conferences before we have a hearing, but in part that's so that people are prepared. I mean, that's in the favor of, I believe, a pro se litigant to ensure that they have as much information as possible going into a disputed hearing. So, and so we often are sort of trying to process all sorts of issues that unrepresented petitioners raise that say they didn't know they had to raise before, they raise it right before the hearing, or, and I think that's actually an accommodation. Because typically the departments are wanting to just go forward, often because they know what they need to do. So I think that's a positive feature in the long run. Ultimately, people are going to have trouble understanding if they're not attorneys. And I don't know how to address that more than what we do, but.
Question, I think, so if we take a civil case in traditional court, you can have a jury trial. And I think the judge, as the adjudicator, is probably a bit stricter on what someone may attempt to enter as testimony or evidence, because you have non-lawyers sitting on a jury and don't want their deliberations to be tainted. If it's a judge trial, my guess is that there can be greater latitude, because this is what the judge does day in and day out, and can differentiate and set aside things that perhaps are mentioned by one of the litigants. Is there any sort of accommodation or nod towards greater latitude in the process that you could speak to?
Yeah, I mean, I think it is possible, say, to do that, to accept information and then ultimately disregard it. But you are doing a disservice to the person that you're disregarding that information of, because you're not telling them that, so.
Yeah, I guess I don't necessarily envision in that way, but giving a little more latitude in their attempt to introduce a piece of evidence or share something before perhaps ruling, where you may have thought you were going to go from the outset as this is inadmissible, but let it play out a little bit, give them the opportunity.
Yeah, I think that we do that. I think, I mean, I think we try. If we would want to give an unrepresented petitioner as much opportunity to explain why something is relevant. And it is true. I mean, we could just simply let everything in and then decide later if we're going to consider it. I just don't think that's a good process. I know you weren't talking about that.
Yeah.
But yeah, I think that's I think that does occur. We do have we do want to, we can't have open-ended hearings either, so, we're setting, this might have a little more to do with the volume of our cases. I mean, we're setting cases for 30 to 60 minutes. We need to go through all the things that we've talked about just procedurally, then get to the issues. Anyway, sure.
We kind of interrupted you, so.
Yeah, I'm not sure where I was. Well, I guess the only other thing I would just say is that, there are going to be people who are dissatisfied with the outcome, and I think the process to some degree. But I think if you look at the aggregate, there are a lot of people who receive, who are ultimately satisfied with the outcome. It's a good process. And, I'll say again, and we don't receive a lot of complaints. And that's the only thing I know, is that I am hearing a complaint today. I've asked, for example, legal aid for feedback on, say, our general assistance housing cases, and I've been told that they haven't gotten any. So I guess I think if you were to look at in the aggregate, there are a lot of people that are well served by our process. And some people are also protected by the same rules that we have to apply to the department's case.
I just asked one more question.
Go ahead.
Do you know, you talked about people's cases being, settled before they get to the Human Services Board. Do you know how many of those cases, were people that just started the process, saw what it was, said, I'm out? Let me tell you why I'm asking that question. I've heard people tell me that.
Right. Yeah, I think that sometimes happens in cases where we start out and they say, you know, I don't want anything more to do with this. And they withdraw. It does happen.
Yeah.
Thank you for representing my client.
Thank you very much.
Another question. You talked earlier, Tony, about working with advocates and legal aid, and you just mentioned kind of working. Can you talk a little bit more? Is that like regular collaboration about the process? Is that a new thing, given the number of cases that hearings that you all have? Like, do you have like ongoing?
We don't. We just had periodic meetings. I think with the GA issues, we sort of started, we've talked a few times. We've had a few meetings before that, which are more general, to all the benefits cases and other issues. So, but no, it's not ongoing.
Right, okay.
I mean,
Are there any other questions? Well, thank you so much for being flexible and coming in early. Conversation. We appreciate your time.
we'll say I was aware of the legislation but I wasn't asked to weigh in on that. So I guess if you want me to, I'm glad to. Not now. But
Yeah, as we short form, so there's not much there right now.
Yeah. All right. Well, thanks again for giving me the opportunity.
Thank you so much.
Okay. Appreciate it.
Good afternoon. I think that wraps up our morning.